All right, good afternoon to everyone who is now watching at this great webinar on artificial intelligence and human rights. Welcome and welcome to the Renew Europe webinar on the implications of artificial intelligence for human rights. And this is hosted by my dear colleagues, Svenja Han and myself. And before we start, I also have an announcement. Unfortunately, due to personal unforeseen circumstances, our guest speaker, Merel Koning from Amnesty International, is unable to participate. But still, we have an amazing panel, amazing speakers that will tell us a lot about this very important topic. So welcome to you all. We very much appreciate your presence. I will be moderating the webinar, and before we start the discussion, I will give our guest speakers the opportunity to give their view on artificial intelligence and its implications for human rights. We will focus on the many questions that arise due to the constant advances of AI technology and its applications. And after the presentations of the expert panel, Svenja and I will ask some questions to our guest speakers. And afterwards, we will open the floor to you, the audience. And if you wish to ask a question, then please post it in the chat and address your question also to a specific person that would help. So the amazing panel, the following experts we have asked to give their take on AI and human rights. The first speaker is Werner Steng, who joined the European institutions in 1996, and he's currently a cabinet expert on the cabinet of Executive Vice President Margrethe Vestager, dealing with digital matters. And between 2006 and 2019, he held different head of unit positions across the European Commission, dealing with e-commerce and online platforms, public interest services, online gambling, and postal services, and with the better regulation agenda. And he earned his doctoral degree in economics from the Vienna University of Economics and Business Administration. Welcome. Our second speaker is Nani Janssen Ravendo. She's a human rights lawyer specialized in strategic litigation and freedom of expression. And Nani is the founding director of the Digital Freedom Fund, which supports partners in Europe to advance digital rights through strategic litigation. And she's also the initiator of the Catalyst for Collaboration project, which offers best practices and case studies encouraging activists to collaborate across disciplinary silos and use strategic litigation in digital rights campaigns. She's also a moderator at the Symposium on Strength and Solidarity for Human Rights, and associate tenant at Docty Street Chambers, and has been an Ashoka Fellow since 2021, and a lecturer in law at Columbia Law School, and adjunct professor at Oxford University's Blavatnik School of Government. Welcome, and thank you for being here. The third speaker is Matthias Pilkamp. He's a co-founder and executive director of Algorithm Watch, and he testified before committees of the Council of Europe, the European Parliament, the German Bundestag, and other institutions on automation and AI, and is a member of the Global Partnership on AI. He serves on the governing board of the German section of Reporters Without Borders and the advisory councils of Stiftung Warentest and the Whistleblower Network and the expert committee on communication information of German's UNESCO Commission. And he was a fellow of Site Stiftung Mercator, and the American Council on Germany. Welcome. And our last speaker is Katja Drinhausen, who is a senior analyst at the Mercator Institute for China Studies in Germany, and her research focuses on the development of China's legal and governance system, including digital governance and the social credit system, as well as human rights in China and state policies towards minorities. So this is the great panel that will inform us about this topic, and I will share some introductionary remarks of events that caught my attention just during the past week. It was the week that the European Commission has launched its regulation on artificial intelligence, and afterwards I will give the floor to my colleague Svenja Han, who is the coordinator on artificial intelligence for Renew Europe. So just a week ago, it's just a week ago that members of the Parliament of UK, Latvia, Estonia, Lithuania, and even my own member state, the Netherlands, were tricked by deepfake video calls imitating Navalny's right-hand man, Leonid Volkov. And deepfakes are named for the deep learning that allows artificial intelligence networks to generate or imitate faces and to have them mimic human behavior. And another example of what just came out this morning shows that privacy of citizens are not always guaranteed. So the Dutch Data Protection Authority imposed a fine of 600,000 euros to the municipality of Enschede for Wi-Fi tracking. And the municipality was monitoring over a longer period of time which telephone passed through the city. And according to the Dutch regulator, the privacy of citizens was not properly guaranteed. Artificial intelligence is based on algorithms and lots of data. And we just know when you look at facts, data is just not neutral. So you often see that an algorithm amplifies differences and biases that already exist in society. And that is why it is very important that we have truly ethical artificial intelligence, which is based on human rights and democratic values. So I therefore welcome an open discussion on how to ensure that Europe truly protects the rights and freedoms of its diverse people. And I'm very happy that we have colleagues and MEPs like Svenja Hahn, who have a lot of expertise on the topic, very passionate about it, to also tell us more. So I will give the floor to my colleague Svenja Hahn. Please, the floor is yours.
Thank you very much, Samira. And I'm indeed very excited as well for our excellent speakers. So thank you very much for coming today and discussing with us the most important issues connected to artificial intelligence, the impact on human rights. We're currently discussing several controversial topics and aspects of this within the Parliament, but also within our group Renew Europe. And the Parliament in the last year worked on 7 different AI reports. And the Commission, as Samira just said, just put forward its proposal for an EU AI regulation last week. And I've been working on all of these reports in the Committee for the Internal Market and Consumer Protection, and coordinating this topic as well in the committee, the Special Committee for Artificial Intelligence. And in both committees, we've already heard many experts on new techniques, on data, and on human rights. And I'm glad that Renew Europe developed a very detailed position on artificial intelligence, and because we all agree on one global goal, enabling digital innovation in Europe, but in full compliance with fundamental rights of our citizens. And we see AI as a huge opportunity for our economy, but first and foremost for our citizens. Well, at the same time, we want to ensure their trust in the technique, and we're not going to make compromises when it comes to the protection of citizens' rights. And as I'm as well sharing with Samir, the Trade Committee, and I'm having a focus on trade in the Asia region especially, I'm severely concerned that AI and other digital technologies could be abused for great violation of human rights. And I absolutely believe we have to prevent this kind of AI uses, as well as the violation of people's privacy and the instrumentalization of digital tools for disinformation and interference in elections. Because we have seen several scandals recently, as Samira just mentioned, in Western countries that has shown us this is not the topic far away, only left for China, for example. These are problems which have to be tackled in the EU, and a common European legal framework is the best way for that. So I'm very thankful that we got the Commission's proposal on AI regulation, and I think it's in general going into a good direction. It contains many important aspects, such as a risk-based approach towards AI. But nevertheless, I'm very concerned about some parts as well. For example, Article 5 of that proposal, in my opinion, is opening the door for biometric mass surveillance. And I believe this is not fundamental rights compliant. And I'm going to fight against that. But I'm very curious to hear from the Commission today about this as well. So I think we're surely gonna hear some very interesting aspects in the coming 2 hours, and I'm very happy to have our 4 excellent experts with us. I'm looking forward to a highly interesting discussion, and thank you very much, Samira. The floor is yours again.
Thank you, Svenja, and I completely agree with all the things you said. So we can move on now to our panel conversation, and we will start with Mr. Stang. I will give you the floor for 10 minutes, please.
Thank you very much. Good evening, everybody. Thank you also for inviting me here. Great event, great topic. Of those 10 minutes, I would still want to spend the first 3 minutes or so to embed the AI proposed in the broader digital strategy, also seen from my boss, the Executive Vice President Vestager, because some of the issues that you raised already in your introduction also go beyond the AI proposal. Of course, we are going to zoom into that. But still, the starting point of this whole commission when it came to digital was our strategy to shape Europe's digital future. And you heard my boss say several times, this is about human-centric technologies. It is technology to serve people, not just AI, but any digital technology is here to help us to serve us. So while we want to have those technologies developed and used in Europe, because that is the present and it's the future, we want that to be done in the European way. So it's a general statement. In the digital decade that you saw published a few weeks, the same vision, and you may have seen that in addition to promoting sort of investment in infrastructures and skills and public services, including EID, by the way, to give more power over data to individual citizens, we also came with this digital citizenship chapter where we said we want by the end of this year a solemn declaration on rights and principles for European when it comes to the digital world. And one of those, by the way, that we mentioned by means of example was about ethical principles for algorithms, for human-centered algorithms. So just to give you an example. The DSA, the Digital Services Act that we published before the Christmas break, also is super relevant from a human rights perspective, because that was all about the content moderation system of platforms, the amplification of content, decisions on who sees what is deleted, what is not deleted, all of that, of course, taken by algorithms, whether powered with AI or not, but still algorithms doing the matchmaking of who sees what. And in that, by the way, there's already also an obligation on recommender systems that I would need to see as a user of the internet why certain content is pushed to me. And if that is pushed to me because of my personal profile, and therefore already there is a risk of discrimination in that, I need to know this and I need to be able to opt for an option without profiling. So just this is by means of introduction, we are looking into these digital issues from several angles, and all of our initiatives are somehow interlinked. Now the AI proposal, I mean, already the title in a way, the European legal framework for AI to address fundamental rights and safety risks. That already shows where the emphasis of all of this is. This is not about regulating the technology across the board because we're all afraid of artificial intelligence. And if there is use of AI in factories for quality control purposes, you know, whether the products meet the requirements, well, be our guest, that's fine. And if as a factory owner, you're not happy with the reliability of that system, well, then you will turn to your supplier of that software. And I'm sure you have a contract with them. You know, that's things where we don't need to regulate on AI, but where we felt we had to regulate on AI as the first in the world actually was on this high risk applications. Of course, I'm sure in the next 1.5 years, we will have long discussions on whether we captured the right risks. But still, the idea is there to focus either on violations of our safety or health. We're sitting in this autonomous car, which changes its behavior after it's been placed on the market, keeps learning, and then it rolls over someone or we are being hurt. So that's, of course, one dimension. And the other is fundamental rights, non-discrimination, privacy. What harm can AI do to us as people, as persons? And there you've heard that the pyramid sort of example, that we have framed the whole regulation in a pyramid form, which means that on the very top, there is only few cases, but those are the prohibitions. And this is really where we think that should not have a place in Europe, where a child is tricked into doing things by a doll using artificial intelligence and making that child do certain things that he should not be doing, or other subliminal techniques influencing us. There's a social scoring model that we don't want to see in Europe. And we also have this, and I'm sure we'll come back to that, Sven already mentioned this remote biometric identification used by law enforcement. We banned this in principle with some very narrowly defined exceptions, and probably I spared it for the discussion later. But then we have these high risk applications. And if you go through the annex, you will see that's always when it really matters to our lives, when an AI may take decisions or help others take decisions that could have a major impact on our life. We are not getting a job offer because we don't have the right gender or age or ethnic background. We may not get a job offered or not awarded later on. We may not get a place at university because in AI things we are not good enough. We may not get a loan. We may not get any social benefits. We may be pursued by the police because our profile happens to be a high-risk profile. So all the attention of the police is on us, and we may be interrogated and put in jail more often than others. Predictive policing, but also other police work. So we have really tried to identify those high-risk applications that we know of today, which can, of course, then be updated as we go along, because we are suggesting here delegated acts to keep that list up to date. Then we have one level lower is sort of the transparency. You mentioned deep fakes as a good example. If we were to ban deep fakes, we would be again in the copyright discussions of the Commission, or Europe is banning memes in Europe or creative works or what have you. But what we are saying is, if there's a deep fake, you should know it is one. Yeah, so there's a bit of a transparency requirement. If I'm being shown a version of reality which is not real, I need to know that. And then at the bottom of this pyramid, there's all the other use cases, which does not mean Wild West, because we have a legal framework in place in any event that bans certain behavior, but not in this particular legal framework. Last remarks, you've all seen sort of then the requirements. What if you are running developing or running a high-risk applications? Well, then you have to make sure that your data is sound and not biased, that you're very transparent, you document everything, you keep records, you inform the users. You have to make sure that the system is robust and reliable, and that there's a human in the loop as appropriate. But with this, probably I stop my first introduction and hand over back to you, Samira.
Great, thank you very much for this. And I think we should also, during the conversation that will follow, we should really elaborate also on how do we organize the transparency and what is needed for that. So let's also elaborate on that, and thank you for the very good remarks. So I now would like to give the floor to Mrs. Ravendo. Please take the floor.
Thank you so much, and thank you for the opportunity to speak here today, and thank you for the excellent opening remarks so far. In this brief intervention, I will address the impact of AI on marginalized groups, focusing on three main issues. First, punishment and policing. Second, essential services and support. And third, movement and border control. And I will address these in turn before making a few concluding observations. On punishment and policing. There's been an increased use of AI and algorithmically driven tools for the policing and punishing of individuals. Well-known examples here are the use of facial recognition and predictive policing technologies in law enforcement. Predictive policing technologies use historical and real-time data to predict when and where a crime is most likely to occur, or who is most likely to engage in or become a victim of criminal activity. European police forces, amongst others in Germany, Switzerland, the Netherlands, and the UK, have been developing and piloting predictive mapping and identification systems to help them preemptively intervene and deter crime. Many of these technologies are based on risk modeling. Individuals are identified and ranked according to the likelihood that they will engage in criminal activity. In the Netherlands, this has gone as far as developing a system that scores the likelihood of children under the age of 12 to become potential criminals. Various studies have shown that the historically biased police data that feed into predictive policing programs is perpetuating and reinforcing the over-policing of neighborhoods that house marginalized groups. Another example of so-called pre-crime detection is the Dutch SIRI, short for System Risk Indication System, that determined whether or not individuals were likely to commit public benefits fraud. The use of this system, which was predominantly rolled out in neighborhoods with low income and high immigration rates, was struck down by the courts as violating human rights. However, the government has since come with a proposal for an even more invasive system, informally referred to as Super SIRI, which would allow for an extended data sharing between not only government agencies, but also private companies. It is important to note that this data-driven policing and punishment is not just carried out by public authorities. It is also happening in private contexts, and it can manifest itself through workplace surveillance, credit checks, private security firms, and also mobile apps. In Finland, the National Non-Discrimination and Equality Tribunal found that a Swedish credit company had to stop using a statistical method that was used in making credit scoring decisions. The credit company would determine if people were eligible for credit or loans, not based on specific information about the individual requesting the loan or credit, such as their income, their financial situation, and their payment history, but instead by scoring applicants based on factors such as their place of residence, their gender, age, and mother tongue. In this specific case, the applicant who filed the complaint was denied a loan because he was a man, lived in a rural area of Finland, and spoke Finnish instead of. Had he been a Swedish-speaking woman living in an urban area, he would have been eligible. Access to financial services, such as banking and lending, can be decisive factors in an individual's ability to pursue their economic and social well-being. And access to credit helps marginalized communities exercise their economic, social, and cultural rights. Automation often polices, discriminates, and excludes, thereby threatening the rights to non-discrimination, association, assembly, and expression. Moving on to essential services and support. Automated systems are increasingly being used to make decisions on whether an individual is entitled to essential services and support, such as welfare or shelter, and the extent to which they can rely on these services. By using AI systems in making these kinds of decisions, those already in a precarious position can be pushed even further into precarity by excluding them or shutting them out. A system malfunction or an inaccuracy can result in serious human rights violations, including violations of the right to life. In the United Kingdom, the government began rolling out universal credit in 2013, which was a major restructuring of the country's social security system, combining 6 social security benefits into one monthly lump sum. The universal credit system was developed to ostensibly simplify access to benefits, cut administrative costs, and improve financial work incentives. Requiring people to apply for and manage the benefit online, however, has resulted in harming those that were already in a precarious position. First, the algorithm turned out to be flawed by not accounting for the way that people with irregular, low-paid jobs were collecting their earnings via multiple paychecks in a month. The system ended up overestimating people's earnings and drastically shrinking the benefits they received as a result. And second, by requiring people to request their benefits online, the system caused hardship amongst people who lacked digital skills or did not have reliable internet access. People would need to fill out long web forms about their personal and financial circumstances and meet cumbersome identity verification requirements while sitting in, for example, a public library, without the option of saving the data entered in case they did not have all the required paperwork with them to complete the process. If you consider that applicants would have to wait 5 weeks for their first payment, it is very easy to see that every day that is lost on not being able to complete a complicated online application process adds to existing hardship. In India, people have been reported to have died of starvation, having been able to access food rations due to the system failing to read their fingerprints for identification. The Aadhaar system is the world's largest biometric identification system and was argued by the Indian government to revolutionize welfare. In practice, glitches in the system are causing terrible problems for the very people it is supposed to be protecting. Decisions about benefits and services are made in a central system, and if anything goes wrong, a range of support can suddenly come to an end. Payments such as pensions are frequently misdirected, and even if a recipient can find out what is causing an error, they often still have difficulty getting it corrected, or they face the difficult choice of trading time that could be spent working and earning an income to undertake lengthy travel to try and speak with officials. On movement and border control, automated systems are increasingly being used in immigration and refugee contexts in ways that are experimental, dangerous, and discriminatory. These technologies interfere with the rights of, amongst others, refugees, migrants, and stateless persons. The use of AI is integrated into facial and gait recognition systems, retinal and fingerprint scans, ground sensors, aerial video surveillance drones, biometric databases, asylum decision-making processes, and other aspects of border enforcement. In this way, they have contributed to the rise to what some have called digital borders. The large-scale reliance on these technologies has reduced human bodies into evidence. In addition, there's a pattern of centralized collection and storage of this biometric and personal data across sectors and agencies, including public-private partnerships such as Palantir with the World Food Programme and Microsoft with the International Committee for the Red Cross. Left without any control over this type of data harvesting, there's been a number of disturbing reports about refugees burning off their own fingerprints out of fear of being tracked and returned to countries of origin or to entry point countries in the EU. From refugees and migrants directly and with informed consent, trends in cross-border surveillance and use of their data without consent are evident across sectors, at UN agencies, at border control agencies, and also with non-government organizations. In conclusion, I want to draw attention to one final issue following these examples, and that is that in understanding the harms of new technologies, it is key to take into account the broader context and existing inequalities and power structures into which they are being deployed. Machine learning technologies learn from patterns in existing data and therefore make it possible to further entrench and exacerbate already existing systemic human rights harms. This, however, is not the same as the usual framing we see in conversations about discrimination and AI, which generally focus on data quality, data accuracy, or quote-unquote bias. The harmful uses of AI just described cannot be improved through improved data quality, as the uses in and of themselves exacerbate structural exclusion and inequality. They therefore need to be restricted and not facilitated with tweaks or improvements. The harms that AI can cause are multifaceted and intersectional. They cut across civil, political, economic, social, and cultural rights. And when they are deployed in the wrong context, they not only threaten the rights of all individuals, to enjoy equal protection of these rights, but they can threaten the very rights in and of themselves. Thank you very much.
Thank you very much for these very, very good remarks. And I'm very curious also about how then, what then can be the solution. I mean, a good point on what you're saying about data quality. That's not all. It's a puzzle that we need to make, so it contains more solutions. And I think that you also made very clear how nowadays also social inequality can be the consequences of how we are working with artificial intelligence and data now. So let's elaborate on that in the further discussion that we will have. So I'll now give the floor to Mr. Spielkamp.
Yes, thank you very much, and thanks a lot for the invitation. I think this was basically a wonderful setup for what I'd like to contribute to the discussion today, because let me first say that generally I myself and we as Algorithm Watch as an organization are very much aligned with what Nani just laid out. From the start of the existence of our organization, we always argued that even though we are called Algorithm Watch, we say in our manifesto that it is important it's not just important, it's basically a prerequisite to having a meaningful discussion about the use of these systems that we call automated decision-making systems, and not so much artificial intelligence, need to be looked at in the broader context of society. And I just use, as Nani already said, one example that I find striking, and maybe we can discuss it later, because there has been a lot of discussion about facial recognition over the last couple of months. And whenever I see that this discussion focuses on, for example, the accuracy of the systems that are in use, I sort of start cringing, because when you argue that, oh, there's a big problem that facial recognition doesn't work as well for people with darker skin compared to people with lighter skin, then first of all, the people who develop these systems, they will always argue, yeah, but this is going to change and it will all be very much accurate in the future and there shouldn't be a problem anymore. But if these systems are used, for example, to monitor and surveil certain groups of society, then this accuracy is actually not an advantage anymore, but ways, it shouldn't be taken into the equation here at all, because what matters is what are the systems used for and how are they situated in this context. Now, trying to sort of map this or apply this to the AI regulation, I first of all have to admit openly that we are still in the very early stages of analyzing and understanding this regulation. It has about 90 pages without the annexes, and I mean, in a sense, I have to congratulate also the Commission on putting this thing out, because it was a Herculean task. And it's sometimes easier to criticize than to come up with a constructive framework of that. So this doesn't mean that there isn't anything to criticize about this. Because in some sense, I do think it is a step in the right direction, because what it tries first and foremost is also to highlight that there are very dangerous and problematic uses of the systems that we are talking about today, for profiling, for categorization, for surveillance, and so on and so forth. Now, the question whether this is going to be adequate needs to be discussed for quite a long time. I try to offer a couple of thoughts on the concrete regulation as it is there, and as I have understood it so far, and where we see that there are open questions, but also opportunities. Now, first of all, this is a horizontal legislation. I guess many people who are listening today or participating here are very aware of what that means, but maybe some are not so much because they're not so familiar with how this works. It basically means that it addresses in a horizontal fashion many, many different sectors of society that are already regulated partly by other directives and other pieces of regulation. So the interdependencies of this AI regulation with regulations already in place are very hard to understand. And I was on a call today with several other people from fellow civil society organizations. And yeah, I can just tell you that there are still more questions than answers at the moment. It's only a week old, so we have to work on that. And the devil, of course, lies in the details with these things. And I'll give you one example here. We have been thinking for a long time about how do we understand what the impact of these systems are. And now the regulation makes the suggestions, or the proposal, it requires that there are conformity assessments being made of such systems. If you look into the expert discussion, then you'll find out that this is in its infancy. We don't have conformity assessments for AI systems. We partly have conformity assessments for such things as cybersecurity aspects of computational systems. But to, for example, argue that there is already a conformity assessment that could be applied for systems to understand or monitor whether they comply with the European AI legislation, then that doesn't exist. But is it a good approach in the first place? We struggle with that because, and I connect that to a different discussion, I mean, also of the regulation itself. we also argued that there should be a public register of automated decision-making systems that are used in the public sector. Why? Because we think basically everything that happens in the public sector is of high relevance to people who are subject to these decisions. Now, the directive says there are certain aspects of public sector AI use that needs to be regulated and that has to have enhanced transparency and also needs to be documented in a EU database. But then there are several other system uses that are not, because they are not considered high risk. Now, I can certainly understand the thinking behind that, because if you imagine that there could be a system, an AI-based system used in the public sector, for example, that hands out parking permits, it's hard to see why this could be a risky system that is being used in the public sector. At the same time, the problem with that argumentation is that so far we have seen examples over and over again of systems that sort of were understood as having very problematic impacts after the fact. You know, they were developed and deployed, and then when people looked at it, civil society organizations, researchers, sometimes public institutions who observed technologies, they found out, or journalists, they found out that, well, this is a problematic use of such a technology. Now, because of that, we think that it would have been a much better approach to mandate impact assessments that look at the system as a whole, and they can be low threshold in a first instance, because we don't want shape and bureaucracy that then basically puts immense hurdles in front of the use of these technologies in all sectors. This is not what we are intending. But if you use low threshold impact assessments to first find out whether there is a potential risk that is coming with the use of these systems, and then on top of that, say, if you determine that that is the case, then you have many of these requirements that come with the legislation, like more transparency, but also oversight, auditing provisions. We think that would have been the better approach. What also comes into this is an example of another larger societal question, or an embeddedness of this discussion, because there is this idea that there should be standard setting for example, something like these conformity assessments. Let me check. I copied the this part of it. Sorry, I can't find it right now, but what it says is that there needs to be standard settings. So companies and also the public sector, the developers and also the deployers of AI systems can use these standards to understand whether there is a problematic use. The process of standard setting is very much dominated by business interests. If you go to standard setting institutions like the IEEE, the ISO, and others, you will find that the committees that argue about standards and develop these standards are basically made up of engineers who come from the largest global companies who have the time and resources and the expertise to develop these standards. So we see that there is an additional layer of a political issue here, because if you then get into the standard setting exercise and you do it in a sense successfully, in the sense that you have standards then at the end, then you have to ask the question, who was sitting at the table? And was that a process that actually is adequate to the democratic process that we understand is necessary for the regulation of these systems? I'll come to a close with an example of where we see an opportunity and where we, at the moment, understand that this presents, first of all, a good example of a regulation, and that is, and I'm not saying that this is the only one, I'm just using this as an example because we have done work on this. And this is the use of AI-based systems or automated decision-making in employment situations. So the Commission now said that whenever these systems are used in the workspace, not just for recruiting, but also for promoting, for understanding people's performance and whether what kind of chances of making a career inside a company. Whenever these systems are used for these purposes, they are considered high risk. Now, this is something that we see as an opportunity, and high risk, of course, just to make clear, does not mean that they can't be used. High risk means that they come with all these provisions that are laid out then in the regulation. So we think this is a positive development, and we have to understand now, and this is something that we'll work on in the coming months, whether we can use this as an opportunity. Because in the labor market or in the labor sector, we have a situation that there is a very limited harmonization on the European level. In contrast to example to data protection, there are some harmonized aspects, but generally the member states say that this is our own sovereignty. When it comes to labor relations, we are in charge. Can we use this horizontal AI legislation to be successful in establishing a higher level of transparency, and not just transparency, but also then based on this transparency, the ability works employees, works councils, and unions to have a better negotiating position vis-a-vis the companies. We see that there is an opportunity, and this is, for example, something that we will need to develop, we will need to analyze further and work on it in the coming months. And we hope that we will be able to identify more of those opportunities. And I'm looking forward to discussing this with everyone here today, because there may be things that we very much.
Thank you very much for the very, very good remarks. And everything was interesting, but what I find, an example of what I find very interesting is what you said about the impact assessments and the last proposal with which you ended your introduction. So let's elaborate on that also in the discussion after this panel. So I would like to give the floor to Mrs. Dringhausen, please.
Thank you very much. I was asked today to speak about human rights implications of China's use of AI and more specifically here, big data use and automated decision making. And that is especially interesting because my co-panelists focused on specific issue areas rather than a country. And that is mostly due to the fact that China is often perceived as a pioneer in many of these technologies, but also serves as a cautionary example of fearful tale of what we don't want in our digital futures in Europe, especially in regards to social scoring. And here I found it quite telling that in some of the reporting or media reporting on the EU regulations, it was specifically mentioned that they are now banning social credit the way it is implemented in China. The other two areas that I'm going to focus on today as well is automated and individualized surveillance and predictive policing and threat identification that also feature prominently in reporting about human rights issues in China's use of technologies. These are the three main issues I want to discuss today. But before I dig deeper into that, there are three main points I would like to make that kind of weave through what I'm going to talk about. First, it is really important to assess China's data-driven practices correctly. The misconceptions and sometimes gap between myth and reality of social scoring practices in China, for example, can block the view on other more pressing issues and more invasive aspects of the surveillance state, for example. Also, and that has featured in some of the assessments and input by the other panelists already, that is often the underlying political priorities and domestic laws and regulations, as well as internal standards in the administration and organizations that use these technologies that are the issue, because they unleash the development and also negative impacts of the use of artificial intelligence and automated decision making and other such technologies. it is a very good idea, I think, to bring China into the picture in this event today. Also because China is a good example of looking at a very different political context and societal context with its own discussions and principles about AI ethics, especially considering that both government agencies and Chinese companies are increasingly participating in international norm setting. And first now I want to start by taking a closer look at China's social credit system, because if you follow media reporting about China, it features most prominently when the China's digital ambitions are discussed. And while the social credit system is part of the government's vision for data-driven governance, there are quite a few misconceptions that I would like to address first. It is often described as an AI-driven all-seeing panopticon, but in reality, it's more an umbrella term for a number of different initiatives, both at the national and at the local level. It's quite a fragmented and messy system of systems. The system, or the system of systems, main purpose really is tracking legal and regulatory compliance, not individual behavior on a day-to-day basis. Also, there is surprisingly super scoring. If you look at the Chinese government sites where information is saved, you'll find digital files merging a lot of different information on companies, partially also on individuals and their legal compliance, but there is no one number. Also due to the fact, and that has been noted by Algorithm Watch before, that is just not a helpful feature for governance to have that one number. What you want is to be able to assess citizen behavior in the different realms of regulatory compliance where they occur. There are city-based scoring mechanisms where you have credits, kind of point systems that also take into account more ethical behaviors, such as donating blood, or that is behavior the government wants to encourage, but these are voluntarily, and new regulation actually forbids making them mandatory for citizens. So there is, while there was potentially experimentation with that idea in the beginning, you can quite clearly also in a regulatory sense see the government, the Chinese government, stepping back from that. Also quite interestingly, considering that is so often held out as this key digital initiatives, digitization is quite limited. It is definitely not AI driven. It is not automated. In fact, the decisions on deciding if an individual or a company has violated laws and regulations are still taken by humans in administrative organizations. They are taken by public officials and then feed into the system, which is also important to understand because it's a key factor where human decision-making and bias still factor into the system. That does not mean that bringing all that data together and trying to assess it in a coordinated manner does not bring its own potential for bias with it, but it is still quite different from the image that one would often have of the system. And I think that's especially important to note because laws and regulations are what defines what lands in the system, or where non-compliance lands in the system. And when you only focus on the technological aspect, you lose track of what is changing in the regulatory environment and what it attempts to regulate. An often used example for the social credit system is, for example, that people are getting fined or noted for not visiting their parents, but just due to the fact that the social security system is relatively weak, visiting your parents is actually a legal obligation. And this is just one example where potentially state regulation of behavior goes beyond what is implemented in Europe, and that is especially true in the case, for example, of what can and can't be said online, and what civil liberties citizens can or can't make use of. And this is increasingly encoded in Chinese state regulations, and these regulations actually feed into the surveillance, tracking, and monitoring systems, of which the social credit system is essentially just one piece of the puzzle. I'm focused on this kind of first round of myth busting surrounding this system, because I do believe getting the social credit system wrong means, one, missing out on realities and debates within China, because there is quite a bit of debate around privacy issues with these tracking systems and databases. And it also sometimes makes it easy to lose track of the similarities that exist with European initiatives for social scoring that some of my co-panelists have already talked about. And that in China, as well as here, define who gets access to loans and welfare. But more importantly, focusing overtly on the social credit system diverts attention from other much more invasive initiatives of the Chinese growing surveillance state. And I would argue that this is where the biggest issue lies, and really encourage more focus to be placed on the broad realm beyond the social credit system. Because quite simply put, the social credit system doesn't need to be the AI-driven invasive surveillance systems just because the Chinese government does have other systems at its service. There is a number of quite ambitiously named initiatives such as Skynet, Golden Shield. You have safe city projects which have a strong aspect of public policing, public security, various systems of online censorship, some in cooperation with companies. What has been noted before is also the turn, not just in China, towards facial recognition and camera monitoring. And what you do see in China that sets it apart and defines the abilities as well is quite a full camera coverage, especially in big cities, but really also in quite remote areas, including in restaurants, in public transport, in classrooms, all gathering information that feed into still fragmented but increasingly integrated systems. And here, as opposed to, for example, the social credit system, where the information is meant to be public to get citizens to abide by laws and regulation, these systems are often quite covert. It is unclear what data is given to whom, and how they work and how they define who gets, for example, targeted by more repressive policies and policing and who is not. And the main thing to note in regard to these broad security-driven initiatives is that they have an underlying overconfidence that technology can be used to effectively predict any risks, both to public security and in China, especially to regime security. And so you have a high willingness to use these technologies in a way that overrides any consideration of individual civil liberties and really places collective security and ensuring the absence of protests, of terrorist attacks, of violent attacks, of any public clashes, be they online or offline, above everything else, and to really drive digitization and use of technologies in these areas forward, which I think is something to pay high attention to, especially from a European perspective. And one topic, I mean, that is actually at the center also of current debates and friction with China is the use of technology and its general policies in minority areas in China, especially in Xinjiang. And here we do see what happens if technology is used with this overarching security goal in mind, because the goal really is to leverage all available technologies and data sources to detect and avert risks. So you do have the mandatory use of spyware, use of apps to enter information about individuals, to collect that in databases for more detailed monitoring. Many Chinese tech firms, for example, have been reported in international media as well to have developed or provided ethnic recognition technology, really enabling a targeted discriminatory system. And here again, I think the point of that use of technology really at its core also reflects government priorities and bias as they're codified in standards is key to understand how far that technology can go. Because just to use one case example of Xinjiang, here the government was trying to define what is normal behavior and what is an indicator of non-normal behavior or extremism. And that went as far as, for example, refusing to drink alcohol or to long a beard or other simple indicators used at indicating extremism and hence warranting, for example, detention or other repressive measures. And systems can help collect that information and set automated alerts for behavior that otherwise would have been just inconspicuous daily occurrences. Again, with that underlying belief that if your spectrum of parameters is broad enough and your technology is good enough, you can avert any risks to the state. Finally, I want to say that understanding how other governments or other states, including the Chinese state, think about these technologies is also key for a future outlook on how to deal with these technologies. Because if you look at Chinese debates, both the government and companies often see these practices as ethical and even contributing to human rights protection, because they're focused on protecting the collective right of public security and the security of the state. And understanding these underlying norms and thinking is important, because both the Chinese government and companies, as I mentioned before, are increasingly going out and participating in both domestic and global norm setting. One example being the Beijing AI principles that were released in 2019 and that were also promoted internationally. And this is only the start of what I'm sure is a more pronounced trend of international interaction and engagement of this topic, where China will play a key role. Just considering that leadership a key part of its current 5-year plan that also sets new goals in smart policing and smart neighborhoods, which is also very much focused on maintaining public and political stability and security. I would like to end with just 2 takeaways for myself as well, based on the previous inputs. I think it's really important to look at the issues and biases in our own practices in Europe, which is something that is undertaken here today, and where EU regulation can really make an important contribution to avert such practices taking root in liberal democracies and ensuring the continued protection of civil rights, because it's really a quick and slippery slope. It also, I think, makes clear the importance of not blindly following promises of efficiency and security, and instead really drawing up legislation or processes and procedures that identify and prevent risks to human rights. And with that, I would like to hand it back. And thank you very much.
Thank you very much. Extremely interesting, the perspective that you gave and what you've been saying, Charles, and so therefore we can learn a lot about a different perspective. And I think the last remarks that you're making about the protection of citizens' rights, yes, that's the essence of the debate, I believe. So we now go to the questions. We have some questions in the chat. And the first question I would like to ask to Mr. Stang. In order for the EU to truly set the global standard for trustworthy AI, that is human rights proof, compliance is essential, and therefore we need the member states. So I wonder, how will the European Commission make sure that the member states comply to EU's AI regulations, and what are the consequences for non-compliance? Because I believe that that you yourself, but also the other speakers, have given us very good and serious examples of what member states and countries in general need to do to make sure that we work with ethical AI. So what's your take on that?
Yeah, it's a very good question. And if you look at the text, at the legal text, and I think Matthias referred to 90 pages of text, is that at least half of that is somehow devoted to compliance and enforcement, because with that, the whole thing doesn't make sense. So the first start is, of course, to say, well, what is it that we want in Europe, and what do we consider high risk, and what do we want to happen with high risk applications? But the next question is obviously, how can we then ensure compliance? And that was not easy. And I think some speakers have also alluded to that, including, I think, Matthias, who can do that conformity assessment in the first place. Yeah, do we have the knowledge and the capacities out there actually to double check whether a well-documented system used by some company actually meets the test of the regulation? And there you have seen probably a difference between the safety-related risks, because that is an easier one, because we have a legal framework in place. Yeah, if a product needs third-party mandatory conformity assessment because it may be a risk to our lives or safety, well, then we can piggyback and say, well, as from now on, you also have to check whether the AI part is compliant. Otherwise, the thing never comes to the market in the first place. But if it comes to all these other applications that we have focused on in our discussion so far or in our presentations, that is much more difficult. So we have very strict rules in place. So if you fall in this category, you are a bank and you use AI for screening of loan applications, or you use it as a university to pre-select candidates for admission to university, whatever it is, then you are legally obliged to comply with all of this. You have to document everything. That's a very important dimension of it. It's not just that you have to check the data quality and all the rest of it, but every step needs to be documented beforehand when the system is developed and while it is used. And that is the basis then for the surveillance mechanism where, and this lies upon member states, of course, where they have to go in there and say, listen, there was a complaint, or we got some other information that your system is not compliant. And then enforcement authorities, market surveillance authorities, data protection authorities, whoever may be most qualified, has then access to all that documentation and can try to find out what really happened, can intervene, can stop it, can take it from the market, can, of course, also at the end of the day fine them. So, I mean, there's a very strong enforcement dimension there. If you're now saying, what if member states don't comply with the regulation? I mean, that's a very fundamental question. But the first thing is, it is a regulation already, not a directive. And that's very good, I think, because it's very clear. These are the rules. They need to be enforced. Voila. If a member state does not enforce the law, well, we have our mechanisms to go after member states with infringement proceedings. I mean, that's the European system. Yeah, we jointly devise law, we jointly enforce it, and then we have a mechanism if a member state does not enforce that. So I would not have any other answer than building on the system that we have.
Great, thank you. I will now give the floor to Svenja.
I would actually start as well with a question to Werner Stang. So we have that in around, and we already got an audience question going kind of in the same direction as I wondered as well. So Vanna, you said that the Commission names it a biometric surveillance ban, but I think that the exemptions for biometric surveillance are in fact very broad, and allowing to use biometric surveillance for law enforcement and danger prevention. And from how I read it, the member states can interpret these exemptions very broadly in line with their national law. So can you share a bit with us, how does the Commission think can these exemptions actually work in practice? And how do you plan to prevent abuse through member states? And especially what I'm very concerned about, why does the proposal allow for biometric recognition uses in public without prior authorization exclusively through a judge, but also during, after, and by another authority? And we actually got a question going into the same direction from Ella Jakubowska, who asked why this real-time biometric identification is only in general prohibited for law enforcement, but not for other state authorities or private companies. So maybe you could give us a bit more insight into that. Thank you very much, Vanna.
The easy question for an evening after a long working day. No, but it's a very good question. And as you can imagine, we have discussed this and debated this internally for a long time. And even when we started work on towards the white paper, remember early leaks of documents triggered that debate immediately and was taken up by everybody out there. So it's a major discussion. Our starting point at the time had been that already today, mass surveillance or remote biometric in publicly accessible spaces is not allowed in Europe. We always referred back to the GDPR Article 9, which means there is a general prohibition, and then it has some very strict requirements when it may exceptionally be allowed, for instance, through union law or through member state law. Probably before I continue, one bracket here. This regulation does not authorize the use of any of the AI technologies. It is not because you are in Annex 3 that you can do all of these things. There are restrictions, not permissions. Yeah, it is, if ever, any of such technologies, including remote biometrics, were to be legally allowed, then we would add on top of this all the requirements of this regulation. That's an important point, because some people had thought, well, this is now a legal basis to do all of this. It's not. If it is legally allowed under the existing law, then this kicks in on top of it. And why I'm saying this, because that explains why the law enforcement has been singled out in the prohibitions. I just said that Article 9 of the GDPR already contains the principle of a prohibition with exceptions. If you look into the Law Enforcement Directive, which is linked to data protection, but it's for law enforcement purposes, there's also an article that refers to biometric identification. It's the Article 10, where the system is inverse. Here, Article 10 says that the use of remote biometrics is only allowed if. So it does not say it's prohibited unless, it says it's only allowed if, and gives quite some leeway actually to member states, because there's no further limitations. Of course, it says in this Article 10, it has to be strictly necessary and proportionate and based on a law. But then law enforcement authorities in member states today have quite some leeway actually to say, well, that is, we define now what is proportionate, what is necessary, and that's now the legal basis for the use of remote biometric identification in public spaces. What we are doing here is we're restricting significantly the possibility of member states to do that, because we are saying we put it into the restrictions article. We said it's forbidden, it's a prohibition unless. You are now saying that the unless is too broad, and that's certainly something we will have to discuss during the negotiations. But it has 5 layers actually, because it first says it has to be one of those situations that are described in Article 5. It's, you know, the search for a victim, including a missing child, or it's a imminent threat to life, a terrorist is on the run, or it is on the list of the serious criminal offenses of the European arrest warrant, provided that at least is punishable with a 3-year sentence. But that is only the first test, and this sets the outer limits. It just says it has to be one of those 3 situations, otherwise you can forget it anyway. Yeah, even if no longer in a national law, you could come with a 4th example, because it's limited to those 3. Then the next hurdle is the judge or authority that can give this prior authorization has to demonstrate that the seriousness, probability, and scale of the harm, as well as the impact on anybody else. So, for instance, an example that I heard during the preparations, if you look at this list of criminal offenses, you would find corruption, right? You would not just find murder and I don't know, all sorts of awful things. I'm not saying corruption is not awful, but it's probably less a risk, an imminent risk to my life in a way. So that Brussels could not say there is a likelihood that a corrupt politician is crossing Grand Place, So let's switch on, the mass surveillance, probably the corrupt politician. No, they would never pass the test of seriousness and probability and scale of harm, and would not justify that other people are being watched at the same time. Then you have this case-by-case ad hoc authorization that needs to be granted. It needs to be case-by-case examined against all of these criteria, needs to be necessary and proportionate. It needs to be restricted in terms of place and time. You cannot say there is a risk that in front of a synagogue, we have to be very careful now because in the next week or so, there may be something. It needs to be a specific event that triggers this authorization because you have evidence that shows there's an imminent risk, and then you switch it on for a limited time in a limited space. Last but not least, members, this is not in itself a legal basis for any of this. If any member state would, in spite of all these restrictions, want to use that, they would have to come up with a specific law. They are not obliged to do that. A member state can say, no, never, we don't do this. And they can also be stricter than that. They can add additional restrictions and limitations. And they could say, no, from this list of crimes, we are only choosing the 5 which we consider the most stringent. So you have to compare this really with the status quo, which is the law enforcement directive. And this is a massive restriction of the possibilities provided therein.
Thank you very much for these very clear answers. So my next question would be for Mrs. Janssen Ravendo. And that's about the marginalized groups within our societies impacted by AI. So do you think these communities are participating enough in the discussions and specifically decision-making? And if not, what exactly should change about that? And what's also the future risk then that we face when we see a lack of also representation coming from the affected communities in the decision-making process?
So like Matthias, I have to say that I am also still reading the entire proposal. So I'm not able to kind of like provide a very detailed level answer to that question with regards to the proposed regulation. But in general terms, I can say that at the moment, the debate is not by far, and the word that's usually used for it is inclusive enough. I think that this is a manifestation of a problem that we're seeing overall, more broadly in our societies, but also within the fields that take an interest in these issues and that have these conversations about technology, its impact on our human rights, and as we work on digital rights. We're seeing a field of actors there that is not representative of our societies. It doesn't reflect a lot of the groups that we were talking about earlier. And I would like to point to a really important comment that was made by one of the viewers from the European Disability Forum, who's actually flagging a number of important issues as to why it's actually practically impossible for a number of people to actually engage with these conversations. So I'd be very curious to hear a little bit what thoughts are there to actually address those shortcomings in the future. But overall, what we're seeing at the moment is a quite a significant divide between those who are engaged in conversations about regulation, about priorities when it comes to digital rights protection, and the actual composition of our societies at large. And I think that there's a lot to be done on very different fronts. One is, of course, work that needs to be done by the digital rights field itself and ask critical questions as to why its composition is the way it is. And as you may know, that Digital Freedom Fund is working together with EDRI to kind of really try and address these structural issues that keep the ecosystem the way that it is. But also in the way that these processes take place in the first place. There often is a very impenetrable method and way in which these these kind of regulations unfold and they are constructed, there should be questions asked about to what extent they are really made accessible to a general audience. Are they being listened to begin with? Is this going to be something that's worth investing in for them? In the process of our initial conversations around decolonizing the digital rights field, we heard a lot of feedback of organizations that actually wanted to participate in conversations about AI regulations, etc., but found it really hard to actually kind of like get on the treadmill, if I can put it that way, of these conversations with really short turnaround times for people to consider white papers, proposals, etc., and having to not having enough bandwidth to kind of like come with formalized positions to weigh in on these processes. So I think that a lot can be done there actually to make it more accessible and make it less of an in-crowd kind of conversation.
Thank you. And before I give the floor to Svenja to ask the questions to Mr. Spielkamp and Mrs. Dringhausen, Mr. Steng, would you shortly reflect on that? So making sure that the process is inclusive and how we engage the marginalized and affected communities.
No, absolutely. I was thinking during this intervention, thinking back as well, because I have a history in better regulation terms. Before I turned to the digital files and so on, I was doing better regulation as head of unit for 5 years and building the impact assessment system and working on public consultations. That has always been an evergreen topic, and not just the marginalized, but much worse than that. Yeah. So how do you get across the bubble, across the usual suspects whenever you consult, beyond the lobbyists, beyond business, even within business, right? It's always a question, how do you get to a small company as compared to a big one, right? Now, and this has always been problematic, how do you get to consumers and citizens in the same way you get to business? I was personally very happy with the white paper, I must say, in the sense that the debate that it triggered. I've hardly ever seen that before. It's not just the number of responses to a white paper, which was also fine. You know, we got 1,250 replies. They also came from many different parts of society, and you will see, and I think it's all published, that there's a lot of civil society contributions that did come in. Also, all the other debates, conferences, workshops that were triggered by the white paper, I got the feeling, and I was personally, and my boss, we were lobbied very much by civil society, at least at the same level as companies, if you want. And I found this extremely enriching and encouraging. And we also had people discussing with us on predictive policing. So very, very different constituencies. Yeah. Now, will all of this have now the same? Did all of that have the same weight? I think it did. It did really influence. If you look into this Annex 3 once again, there are so many things now, either in the prohibited practices or in Annex 3, which probably I would not have expected a year ago, but now they are in, right? And again, predictive policing, just one example. Yeah. So probably that's too positive an answer for your sake now, but I personally felt that the involvement of the non-typical and non-usual suspects was very encouraging.
That was interesting. I'll actually have the next question to Matthias Spielkamp from Algorithm Watch. Actually, maybe you want to add on a bit how you view the aspect of biometric. We heard Vanna already point out the Commission perspective on that, and I would be very keen to hear your input on, do you really see this as a total ban, or are this exception okay, or are they too broad? What's Algorithm Watch's point on that?
I will be a little, let's say, take a low profile on that, because this is actually not what we are focusing on as an organization. What we did is we joined the, first of all, an open letter, but that was led by EDRI and Access Now and other organizations who do more work on this than we do, because we found it convincing that it is time to ask for a ban of such nature. Now, I listened very closely to what Werner said, and he knows his legislation. I think we need to reassess this, because this is also one of the aspects that we discussed. Is it actually legal for the public sector if it is not police? Or is it legal for the private sector to use such systems? Now, Werner argued, in my opinion, quite convincingly, that that is not the case, but there are additional requirements if this is, for example, then if these technologies are used by police and law enforcement. Now, can I answer this off the top of my head? No, I can't. The thing is that in the end, what we would like to achieve is exactly what we have been discussing now, that there is the use or the deployment of live facial recognition indiscriminately in public spaces cannot be done in the European Union. Now, is the regulation here enough? Is the combination of the GDPR and this regulation enough? I can't answer that question at the moment. What I think is important now is also to keep in mind that we are talking about a proposal. So this proposal is now going into all the discussions that are waiting for it in the parliament, but also with the council. So there may also be attempts to water this down and to change this proposal. Now, even if we came to the conclusion that it's okay as it is, and as I said, I can't really say whether that is the case, then we would still have to fight for the provisions to remain the same, instead of being struck down in the lobbying process that is now going to ensue.
Thank you very much, Matthias. That was actually very interesting. And I hear that this is going to be a discussion that will continue over the next time. I have a great honor to ask another question to Katja. Thank you so much for presenting on rights abuse through digital technologies in the case of China. I was especially shocked that it's a duty to visit your parents. I mean, I normally do that regular if it's not Corona, but if it's a duty, that seemed very shocking as well, and shows like just how deep this control of life through digital means goes. We have a quite broad discussion in Europe about using technology to oppress people, and there often seems to be a conflict of interest. Can you work with those companies? For example, in the European Parliament, we have thermal cameras in use that are from the company Hikvision that is involved in human rights abuses in the Xinjiang region. And we have a big discussion about the 5G rollout. Maybe you could enlighten us a bit about how close is the cooperation between European states and questionable Chinese tech companies? Do you see some dangers there? Or do you know about like European companies who are directly or indirectly supporting human rights abuses through technological means? So maybe you can share a bit about that, or how in general, like European leaders should react to China's normalizing of mass surveillance.
Thank you, Ms. Han. Normalizing mass surveillance or normalizing use of ICT really for quite individualized and pervasive tracking with various different policy goals is actually the main theme, I guess, of what I was also hoping to talk about if that question arises, because what can't be overstated is the government's confidence and belief in these solutions for better governing China, really, for keeping the country safe, stable, for ensuring no protests, for ensuring territorial security. So what you will see is, what you are seeing within China is a broad buildup of, again, use of cameras, facial recognition technology. If you look at, for example, topics like security fairs, there's an increasing thirst also for biometric data solutions and integrating them with safe city and other policing systems. a term that pops up sometimes is that of technological stability maintenance or stability management. And a lot of these applications do have human rights implications. But it is such an important pillar of domestic governance itself that hardly any Chinese tech company is not involved, because the solutions needed to build this system, from databases, from like hardware such as cameras, to cloud services, to information sorting systems and services and solutions for at least semi-automated decision-making and filtering, that you can quite safely say that a lot of China's big tech companies that are also active internationally, selling products abroad and working with European companies here, or relying on input in terms of technology from European companies, are involved in one way or another, sometimes directly, sometimes remotely. And while I cannot give you a complete list of examples here, because I'm mainly focusing on China's domestic applications, this is something that should be further, well, actually resources should be put into further understanding and analyzing those connections, especially looking at the broader picture of the various different users, again, from relatively non-invasive social credit and online digital files to really quite individualized tracking of, as it is called in China, key groups that pose a risk to state security, and really identifying their movement networks. The broad realm that I didn't even really talk about that much today, which is online censorship, which is quite targeted at identifying online dynamics, at information going viral, preventing information to go viral, as was quite visible in the early stages of the pandemic, and trying to contain information about what was happening initially. So this is a really broad realm where companies can be and are involved in so many different ways, and again, perceiving their own actions as contributing to public security, as contributing to good governance, as it's often framed domestically.
Thank you very much. And we have now also questions from the audience. And I suggest that we are going to ask these questions now to you. And there are actually many questions. So first of all, thank you for participating. There was an interesting question for Mr. Steng. So about the transparency of the obligations for deepfakes, and basically Tiago Carolino is saying the transparency obligations for deepfakes providers stemming from the proposal could be easily circumvented by social media users. Deepfakes, with the help of social media, may in the future have far-reaching implications, especially during elections. The current proposal doesn't address this. So will a subsequent proposal focused on misinformation or the protection of democratic processes, will that still follow?
Yeah, thank you very much. Excellent question. Rather complicated answer, perhaps, because it's not just in the AI initiative that this phenomenon is addressed, right? Here we're talking really about AI, and to the extent that AI may have certain uses of AI may lead to certain problems. You could also have a misinformation based on a very skillfully done manipulation of a photo without the help of AI, but it still looks pretty good. You're very gifted in cut and paste and what have you. And then you disseminate that on social media, and then people think to see something which is not true, or a politician doing certain things he or she has never done. So what is now the difference whether it's AI or not AI, which is also why it is addressed in different contexts. It is addressed in the Digital Services Act, if you want, which we proposed before the Christmas, because to the extent that it is illegal as such, it is regulated by the DSA. Let's assume you do a deep fake now, irrespective of technology used to create that, and this is clearly defamatory in nature and is illegal under defamatory laws, right? Or think of other scenarios, I don't know, where it is inciting to terrorism or whatever you can possibly imagine this deep fake could try to convey to people. But in that case, it would be illegal material. The DSA applies once it's adopted. The platform has to remove that stuff expeditiously, and all the procedural consequences follow. If it is not illegal, but still disinformation, then it falls under the disinformation agenda, where we are just revising the code of practice, where things that are not illegal, we were not legally obliged to remove. But still, we want, of course, platform to act more responsibly and make sure that someone who on purpose disinforms people for whatever reason would no longer generate money with this, follow the money approach or other things, that you have fact checkers, that you have all sorts of mechanisms there to make this disinformation visible to people, make sure it's not seen so prominently. So that's another one. And here in this proposal, we are really talking about the specific sub-case of what I just said, when AI technology is used for that purpose. That alone already has to be made visible to people, but all the other things apply simultaneously if you want.
Great, thank you. Then it's for all panelists, this question, but I would like to start with Mr. Spielkamp to answer. The question is like this: do you think it's tenable to use tailor-made AI or reverse engineer AI to identify and mitigate risks and ensure compliance to regulations?
Yes and no. So first of all, we have been using this as a method basically since day one, meaning that we designed experiments where we tried to probe and test complex algorithmically based systems from the outside. Let's say recommender systems like Google search, find out how does it behave? Does it give preference to certain content if people have individualized search results or something like that? Now, let's say the money that you have to spend on that and the efforts and the resources are enormous, and the results that you can produce are usually only indications of something. No, I would say it is not possible to this aspect of reverse engineering to meaningfully use that as a method to ensure compliance with the regulation. And I'm leaving out this, again, entire question of what do you win by understanding the system a little better if, let's say, the context is problematic in the first place. At the same time, yes, I do think that we need to develop technologies, especially when it comes to auditing existing systems, because there will be such systems, right? They will be used, and we need to find a way to understand better how they are used, what their characteristics are, and whether they are problematic or not. So we do need to develop auditing technologies here. Whether these then are in themselves AI technologies, the algorithms that control the algorithms, is basically pointing in the wrong direction. Because what we have to understand is, what is it that does the trick? So let's say we just developed an impact assessment tool for the use of automated decision-making systems in the public sector. What is that assessment tool? It's a checklist. It's two checklists, but this is already too much detail. So it's a checklist in the sense that the organization that would like to develop and deploy a system, a computational system, to do a certain thing in the public sector, they need to use this self-reflective approach to understand better what the implications of the use of this system is. And then they need to answer questions. And then they have to provide a transparency report. Is there AI in that checklist? No, there's only real intelligence in the sense of human intelligence that is needed to assess these systems. So as I said, there may at some point be also technologies that are used, let's say, to find out whether there is a certain problematic data set or something like this, but it will always be a process with a lot of possibility and also requirement of insight, for example, being able to test the systems actually on the ground and not just from the outside. And it will always be dependent on the, let's say, the quality of expertise of the people looking at this and how it is embedded in the larger context.
Great, thank you very much. Then we have also a question for Katja from the chat, and it's from Green Tiffany. So to what might we attribute the overconfidence in the certainty of these systems? So how might we encourage a greater appreciation of uncertainty? To Mrs. Greenhausen, please. Sorry, we can't hear you.
Oh, sorry. Yes.
Yeah.
Hopefully now. I don't have an answer how we can encourage a greater appreciation of uncertainty and just the risk of failure of these technologies, because I think this question itself comes from a place where you're aware of its risks and want to protect the impact on the individual, because individual impact can't be sacrificed for greater, or shouldn't be sacrificed on principle for the greater good of, for example, public security and public interests. So this is just a very different angle with which especially the Chinese leadership looks at the use of these technologies. And this kind of confidence or overconfidence in these technologies, I think, is rooted in a number of things. One point that is often raised is, for example, that China hacks of big public protests, as we're seen, for example, in Hong Kong, and is often contrasted with the calm and order on or in mainland China. That was or is presented as a direct outcome of its governance approach, including the use of technology to maintain public order. Then another very recent confidence boost, I would say, was how the government managed to contain the outbreak of the pandemic in the end. And a lot of that is attributed for being open to the use of technology, including individual tracking and tracing through apps, through including quite broad public security exemptions that allow the government to demand data from companies, so very low boundaries, and therefore granting access to data in any situations that are defined as a security risk, and then being able to use that data for big data analysis, partially automated decision making, and this recent success, to some extent, I think, is also seen in the digital sphere, where the government has been much quicker in terms of containing disruptions of online discontent. For example, when the Dr. Li Wenliang, who was one of the first to draw attention to the new pandemic with blog posts and was first censored by the police or internet police, when he died, there was quite a big public opinion storm, as you would call it within China, with people calling for freedom of expression. But 24 hours later, also with the support of algorithm-driven online content moderation, all these entries were gone. And if you look at earlier crises or public events, such as the crane crash in Wenzhou or shoddy buildings crashing and students dying after or as an effect of the earthquake in Wenchuan, in Sichuan, there was a big public outcry and continued online discussion and debate and criticism of the government for weeks or months to come. So this sense of now being able to much quicker contain any threats and crises is definitely a source of confidence, and one reason why this high tolerance of error margins in terms of effects on individual rights exist.
Thank you. So we're moving already to the end of the webinar, but we still have some time for one question, and I would like to ask this question first to Mr. Stang, and then Mrs. Janssen, Ravendo, would you like to also comment on that? So the question is, why the European Commission did not prohibit the application of biometric identification in refugee camps and on the border. Civil society claimed that it can heavily endanger rights of refugees. For example, get their food only after iris scanning, getting access to the camp after giving fingerprints, emotion identification experiments. These are examples that are part of the question. And moreover, European Commission not only prohibit it, but also finance the development and deployment of such projects. How can you comment on that?
So I can only comment once I successfully unmute myself. First, probably a general remark, because we are now obviously always talking about the risks and what can go wrong. But of course, the main reason why AI systems are being used by public sector, as much as by private companies, but here we're talking a lot about the public sector, is of course that the public sector thinks that they can deliver their functions more efficiently, more effectively, more reliably. So it's not that there's always the evil bureaucrat that says, now let's use this opaque, black box system to screw people. Very often it's just let's do a better job here and more reliably and more efficiently. And if you have discussions with the security people or the law enforcement people, which we did not have in this webinar today, you would of course hear very different stories of how important it is to use data and such technologies in our increasingly digital world, where criminals of all sorts are extensively using that and becoming much better than our law enforcement people that are lagging behind 10 years in any event. Yeah, I'm just giving this as an intro also to show a bit the other side of the argument. Now, we have focused indeed on remote biometric identification / mass surveillance, not least because this is where we have the existing legal framework, both GDPR and the Law Enforcement Directive, as already explained, and where we just felt this was by far the most intrusive use of that technology, that many people are being looked at the same time. You're looking perhaps for someone specific, but by doing so, you identify hundreds, if not thousands, of other people whose privacy should absolutely be protected. So that's the most intrusive way, and that is why it is in the prohibition section. We have also said that other uses of biometrics may not necessarily be problematic. And of course, one extreme case is now your telephone, which you unblock with your face. That's also use of biometric technology. We're also saying in a one-to-one situation, it's much less problematic. You are crossing the border and your identity is checked against your passport, just your identity, and that data is deleted afterwards. That is not mass surveillance. But that said, if you look again into Annex 3, you will see that, specific to your question, that there is a long chapter, specific chapter on migration, asylum, and border control management with 4 specific use cases identified there. each of them referring to AI systems used for specific purposes. And this includes all the purposes that you have in your question, which means in spite of this not being mass surveillance, we are still saying, hang on, as you rightly says, things can go terribly wrong here. Therefore, we need this increased scrutiny and transparency. And if a system is now used at the border to identify people with facial recognition one-to-one, and the system is not capable of identifying with great reliability, but then it's a system that can be used. So it's a bit of a long answer, but it's a multifaceted question.
Nani, would you like to comment on that?
I would. Again, unfortunately, not in the great level of detail when it comes to the regulation, but a couple of points of reflection there. I fully understand the point that, that we shouldn't assume that people don't come into these conversations with good intentions. But I do think that we should question sometimes which intentions are given greater weight in these conversations. And to the extent that I understand the scope of the proposal as it currently stands, I think it's really clear whose interests put more weight in the scale here. And when we look at the application of these types of technologies in the context of indeed border enforcement, in migration, refugees, etc., the factor of human dignity is completely not taken into account. There may be increased scrutiny, there may be increased transparency, but if this actually doesn't go with the possibility of those who are potentially being harmed and affected by the use of these technologies to actually stand up and protect their rights, we're looking, as I understand it, to a regulation that leaves a lot of the determination as to whether or not technology is compliant with the companies that actually develop it. I think that there's a huge imbalance of power there, and actually we should be erring on the side of caution in the sense that we should be kind of like acting from the principle of protecting the people that are going to be affected by it. And this kind of comes back to the point that I made earlier, is that it's not just about closer scrutiny of the technology, greater transparency of the technology. It's not purely a technological question, it's a context question also. And I think particularly in these situations, and this is also why I included this in my remarks earlier, we need to look at this much more holistically than purely as to whether or not we can meet certain technological standards.
Great, thank you. And unfortunately, we need to conclude now. And I have some final remarks to make, and then I will give the floor to Svenja, who will close the webinar. So first of all, thank you very much for all of the questions coming from the audience, but a special thank you to the panelists. I have learned a lot. So we have learned that the European Commission has just launched its regulation on artificial intelligence, and that's very good, because regulation is an important step addressing the most harmful applications of AI, particularly with the inclusion of Article 4 on prohibited artificial intelligence practices. And the inclusion of prohibitions shows that the Commission is serious and is placing limits on applications of AI that are incompatible with our fundamental rights. And I really would like to compliment the European Commission on that. And Margaret Vestager, Executive Vice President for A Europe Fit for the Digital Age, said something very important. On artificial intelligence, trust is a must, not a nice to have. And I must say that I could not agree more, but we also hear the remarks coming from civil society experts that are concerned that even transparency measures target the transparency of providers towards the users, but not transparency of users towards people affected. They also warn that in order for the proposed law to protect people's rights, it must go further. Different actors, including governments and experts, fear that the use of AI will continue in ways that lead to discrimination and surveillance. And I think that we've all recognized that today, and that we all agree upon that. But we also need to decide on what do we do with, for example, predictive policing, uses of AI at the border, automated recognition of sensitive identity traits, uses of AI to determine access to essential public services, and many uses of biometric systems. All that can lead to mass surveillance. So these are some of the red lines set up by many civil society actors, but what I also hear from you is that you are seriously thinking about these very serious questions and concerns. And I have all the trust in that we will find the right solution if we work together, and make sure that the process is inclusive. So as a co-president of the Anti-Racism and Diversity Intergroup, I will be very much focusing also on the effect and the impact of including artificial intelligence and other automated decision-making systems when it comes to public life, public services, because of the impact that it can have also on racial and ethnic minorities. And very important questions that I'd like to see to be answered is what measures will be introduced to make sure that encouraged self-assessments are based on expertise and sufficient ethical standards. Will AI developers be able to predict and prevent some of the negative biases? And are affected communities participating enough in these discussions and decision-making? These are just a set of examples of questions I have. And then finally, I would like to say that the EU's vision for AI must be one that puts fundamental rights at its heart. So I welcome very much the open discussion on how to ensure that Europe protects the rights, freedoms, and democratic values of its diverse people, because after all, we are united and in diversity. Thank you, and I would like to give the floor to Svenja.
Thank you very much, Samira. That was a really, really wholesome wrap up. Thank you very much to all our experts for sharing your expertise with us today. I think one thing is very clear. This is a discussion that we're going to have in the next years. And I'm very happy that we're having a proposal on safeguarding artificial intelligence, safeguarding human rights, citizens' rights, and fostering innovation. And by creating a legal framework, the EU is actually doing some kind of pioneering work there, because we're the first trying to put a legislative framework for artificial intelligence. I think the challenge is going to be that we're not going into over-regulation, but really setting a solid base based on our European democratic values to actually foster innovation and safeguarding our citizens' rights. So this is going to be a very, very interesting discussion. I'm very certain this has not been the last event we had on this topic. I think there's more to come in the next year, so I can really recommend all of you that have been joining, keep out on the look for more events on this, but also maybe follow our experts on social media, get in touch, get involved on this topic. Thank you to all our experts today. Thank you for the teams making this possible. Thank you as well to our translation service. And I wish you all a very nice evening.